few minutes after 10, call the meeting to order, the meeting of the Ad Hoc Committee on Transportation. And we'll start at the table, go around with introductions, and we'll start with you, Mr. Wheeler.
Dennis Wheeler, Municipal Attorney. Dean Gates, Assistant Municipal Attorney.
Julia Tucker, Assembly Counsel.
Tim Steele, Assembly.
Amy Bombasti.
Bernie Hall.
Bill Evans.
Duke Training.
You all should have copies of the agenda. Are there any suggested changes or additions to the agenda? Okay, seeing none, the agenda is approved. What I'd like to do today, I think the agenda kind of lays it out, but we have two proposals that have been submitted to the Assembly already on the so-called Uber issue or revising our transportation for TNCs. And I'd like to at least start the meeting by reviewing both of those proposals. I'd like to have Mr. Trainey kind of go over his proposal, discuss what it does, what it's for, what the goal is, answer any questions that we may have about it. We have Dennis and Dean available too to answer any of the legal issues that stem from those proposals. I'll then address my proposal, which is different than the one proposed by Mr. Trainey. Do the same process. Once we're done with that, I want to open it up to other possible options. There's also the option of allowing Uber or TNCs to operate as taxis under Title 11. Have any discussion we'd like to have on that. I'd like to hear generally from the legal department as between Mr. Trainey's and my proposal, whether the legal department or the administration has any preferences or sees any problems with either of them. And then the last couple issues, I think it's obviously necessary that if we make any changes with respect to TNCs, we want to make sure that we do so in a manner that's fair to the entire industry. So I want to address any other...
And the citizens of Anchorage.
And the citizens of Anchorage. And I want to make sure then we have time to discuss other changes that may want to be made to Title 11 in order to level the playing field or open the playing field as it may be. So with that, I'd like to turn it over to Mr. Trainey to discuss his proposal.
Thank you, Mr. Evans. If you look at mine, what it does in line 23, section 1, calls for a memorandum of understanding to be created between the TNC and the municipality. And then section 2 goes over the different provisions that the TNC and the MOA would agree to in this memorandum of understanding presented to the Assembly. The different things we want it to encompass. It's not that hard to do. We just need the administration and TNC to come together and see how we can make this system work for a pilot program. Because I think there's enough service out there, enough clients for both taxis and a TNC to operate in Anchorage. And that's it. It's in front of you.
Ms. Zabowski.
Thank you, Mr. Chair. So, Mr. Trainey, I just want to make sure that people understand, and you're in concurrence, that if this memorandum of understanding, if this passes, it just gives the opportunity for the administration to engage with a memo of an understanding, but it wouldn't actually be effective until it's approved by the Assembly.
Yeah.
Right, so what I'm reading is the municipal attorney and the city manager, but it also has to be approved by the Assembly before the TNCs can actually, the memo of understanding can be
That's what
effective.
memorandum of understanding does right now.
So I just want to point that out for people. This isn't just throwing out all the rules and then the Assembly doesn't get to weigh in again.
Well, sometimes the rumors are a lot bigger than reality.
Thank you.
Any other questions for Mr. Trainey? I have one, and it may be for, I don't know if it's more appropriate for Mr. Wheeler or Mr. Trainey. I know other cities have followed this approach. What, in the interim, while the discussions are going on to enter into the MOA, what generally happens with the existing regulations? Are taxi cabs and the industry affected, or they continue as normal? And what about the operations like we currently have Uber offering, free rides? What would happen with them in the meantime?
Well, since we got 4 members of the bar here, I'll let you two discuss that. Because I think we've got Barbara here and we've got Joey here. So we've got 4 members of the bar here.
Through the chair, assembly members, as I read this AO, the provisions of Title 11 would be in effect waived or suspended with respect to any operator under an MOU. So they would be able to then operate and charge customers for a fare, whatever the fare rate is going to be applicable to them. And whatever the conditions of the MOU are would supersede and affect anything in Title 11.
Mr. Hall, do you have a question?
Yeah, it plays somewhat along the line of what you just asked and how this applies area-wide. Because the thing that's always been kind of on the back of my mind about this is I remember when I was given the oath of office that I would abide by, follow, and enforce the rules of the federal government, the state, and the municipality. And, you know, we've got in law how we deal with transportation. So I guess my question is, do I end up with a conflict here at some point in regards to trying to make an exception, or that part confuses me?
Through the chair, Mr. I'm sorry, I'll yield to Mr.
Go ahead, Dennis.
Mr. Hall, one of the things that we're concerned about is what impact this would have on the other participants in the industry, and whether or not they will feel compelled to assert claims against the municipality regarding their investment, if you will, into this regulated industry. And we're working on that, and Mr. Evans has asked us to give him our best judgment as to what those claims might look like and what the probability of those claims being successful would be. We're not prepared yet to answer that question. It largely depends on how either amendments to Title 11 are structured or this MOU is structured. And we've got two things going on. One, we've got to look at the case law and kind of ferret out what fact patterns in those cases led to the results, and then look at what is being proposed and see if we can't, if it's the will of the body, create an arrangement either in the MOU or in Title 11 that avoids the issues that tripped up the courts in those other cases or led to a result that was not good for the city involved in those cases. We have two competing cases that are primarily cited. There's one out of Chicago and one out of Minnesota. And we're looking at those and trying to look at the cases that have come since then and see where those fact patterns come into play. The trick here is that Alaska's Constitution has an extra provision in it regarding what we call regulatory takings or per se takings. And so Alaska courts, because that constitutional language is more expansive, tend to trend towards findings that are even more favorable to the person asserting the claim that they've been harmed by government action. So where a federal court might not find a taking, the Alaska court could still find a taking because of the difference in the two constitutional provisions. So it's not an easy thing to work through.
I guess I'd follow up and ask the question in a little more direct manner. Would an MOU set aside city code?
This proposal does do that, yes. But having said that, because it's in the form of an ordinance and you hold public hearings, the assembly can giveth and taketh away, right? So you do that all the time. You change code all the time. You occasionally waive code, sometimes in Title 21 in terms of public notices. You waive it sometimes in Title 3 on labor negotiations. It's just a question of whether that's perceived as being completely arbitrary or whether you identify reasons to do so. And you have a lot of discretion in that regard.
Mr. Training and Mr. Boston.
But you know, that's our function as an assembly. If in fact the Department of Law and Administration comes up with an MOU that we as a legislative body can agree to, then we can pass it. And it doesn't circumnavigate the law, and that becomes a law once we pass it. That's the reason we've got this MOU to come to us from the administration and the Department of Law. You'll be doing the legal work for us to make sure it's legally viable. We can also regulate the area. We could have it apply to Eagle River, Chudiak, Birchwood, Girdwood, areas that are underserved right now. So it gives us the ability to modify the service being delivered to the citizens of this town.
Ms. Dombrowski?
Thank you, Mr. Chair. Though I am not one of the 5 attorneys in the room, Mr. Wheeler, I think your language should actually be clarified, because what you said, this MOU would set aside Title 11, that's not in fact accurate. This isn't an MOU, this is a mechanism in which the city can even talk about developing an MOU. Is that correct?
Through the chair, Mr. Bosky, I'm looking at the last section of the AO, not the last section, section 5. It says we're seeking temporary suspension of Title 11 regulation under a MOU. And
Right.
one of the possibilities is we could take certain sections of Title 11 and incorporate them in the MOU.
Sure.
But at the end of the day, the primary provisions that we're going to need to waive, if you will, or suspend, are those that would identify this entity as a dispatch service or a taxi cab
Sure.
service. So we have to work around those. And we have to make sure that in Section 2, whatever these topics are, we have to identify how to do those. Some of them are going to be potentially more or less stringent than what's in Title 11. So Title 11 would be waived to the extent that they at least deviate from those.
Sure, and I just want to go back to Section 1. You're looking at Section 5, I'm looking at Section 1, and it says, basically, provisions of the current code notwithstanding application, yada, 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 and then you get down to line 26, when a memorandum of understanding between the municipality is developed. So this is not an MOU. This is a mechanism in which you can have those discussions, and this, to me, all those issues we're talking about, Title 11, like you just said, I mean, we can take those portions of Title 11 and put them in the MOU, right?
Yes.
So to me, this right here does not, I think it's a complete, I think it's misguided, and we're leading people down the wrong path when we tell them that this basically, this right here supersedes Title 11. There's nothing here that supersedes Title 11 because there's no MOU yet. Does that make sense? Or am I completely, since I am not a member of the bar, I may be completely off base, but my understanding of this isn't a mechanism, and you're one of the people that have to review the MOU. So my hope and my thought was anytime something comes up and the mayor has that opportunity to develop an MOU, the administration, you'll say, okay, well, this needs to be in there, this needs to be in there, and we'll get that from the municipal attorney's office. Is that what you're thinking?
Through the chair, Ms. Dombrowski, the way that I understand this AO is that it gives us the authority to enter into an MOU with a service that would otherwise, under Title 11, be a dispatch service. It would need to come in and get the dispatch license. It would need to have taxis. They would all have to be licensed and have the chauffeur license, et cetera, et cetera, et cetera. This MOU gives us direction that they're not a dispatch service. They're some other kind of service, and they're going to have drivers that meet certain requirements, but they're not going to be considered taxis, and they're not going to go through that licensing process. So this gives us direction to avoid those code requirements under a pilot program to provide this service.
Sure. And going back to the MOU, but the MOU would not be in effect until it was actually passed by the assembly.
Correct.
Okay, that's what I was getting at. Thank you.
Any questions? Seeing none, I just have a quick question. Since this proposal, Mr. Trainee, arose from the assembly, but really requires the administration to enter into the negotiations with Uber, do we know yet if the administration is on board with this, doing this approach?
I have no idea, but I'm sure if we pass this, they would be on board on it, because they execute the policy we directed to do. So I wouldn't anticipate they'd throw it in the garbage and not decide to do it. They'd take a look at it and come and give us their best answer if it can even be done. But this would be the direction of the assembly, ask the administration to take a look at it.
And Mr. Wheeler?
Mr. Chairman, to answer that question, from our perspective as the legal department, we work for the assembly just as much as we work for the administration. So if your direction to us is to develop an MOU for your purposes to meet this AO, we will do that. If the mayor has some objection to it, he would certainly have the ability to either veto the AO or express his concern about any provision that's in the MOU in your deliberations.
And just as a follow-up, I'm just a little fuzzy on the mechanics of how this would work with respect to determining what parts of Title 11 we'd want to incorporate or waive or modify. Who would be, in that scenario, obviously if the legal department's entering into those discussions, who's giving you your marching orders as to what is acceptable then? Or does this just kind of give you that ability and then
We are,
come back?
through the chair, Mr. Chairman, we're going to use section 2 of this AO, and if there are blanks, and we think it's appropriate in the interest of the public to add in or fill in those blanks, we'll do that, and then if we reach agreement with Uber on those points, that will be clearly indicated. If there's a dispute on those points, one way we could handle it is to say, here's where we disagree. The whole thing comes to you in the form of an AM, and you can give us further guidance. If you want to resolve it one way or the other, that final decision would then be incorporated into a document that would actually be signed.
Any other questions regarding the so-called training proposal?
Just one.
Mr. Trainee.
I trust the legal department. They work for us. They work for the executive. They also work for the legislative branch. When we pass a law, Julia can draft it, but Julia never defends it in court. Everything we pass is defended by this gentleman over here in his department. So I trust them to take, if we pass this, and create the memorandum of understanding. That's their job.
Seeing no other questions, we'll move on then to the second item, or actually the fifth item on our agenda, which is my proposal. Hand you the gavel if you want to share this while I spew about this.
Mr. Evans, sir.
Thank you, sir. My proposal, which you have the S version in front of you, takes a different approach, sort of the same issue. Instead of authorizing the administration to enter into a memorandum of agreement or understanding with Uber or any of the TNCs, this takes a crack at actually amending the current Title 11 to incorporate TNCs as a new type of regulated system, to use a better word. And I can go through it kind of quickly for you and then answer any questions. Basically, it starts with providing some definitions of what a digital dispatch is. It defines personal vehicle because, as you know, these TNCs use a different method than taxi cabs or people using their own vehicles, which are not always being used for commercial purposes. So we had to define what a personal vehicle was in this context. It defines what a transportation network company is, these TNCs. It also defines what a TNC driver is and what a TNC endorsed vehicle is, because the main purpose of my proposal is to bring the TNCs under some form of regulation. It's not the same regulation, as you'll see, that affects the taxi cab industry or even the vehicle for hire industry, but it does provide some of the basic regulations that I think are important for anyone commercially offering transportation in the city. What it does require generally is that the TNC company be licensed by the municipality. So for instance, Uber or any of Lyft or any of those others would have to apply for a license and be approved by the city. It requires their vehicles to be inspected, not the exact same manner of inspection that occur with the taxi cabs, but requires them to be inspected by a licensed and certified mechanic, and that those proof of those inspections be available to the transportation inspector. It requires background checks on the drivers for these TNCs, and it requires, let me see what else we have. It basically does not it doesn't require TNCs to be taxi cabs. It creates a sort of separate, completely separate entity that is still under the jurisdiction of the Transportation Commission in these regulations. It has an insurance requirement. I mean, we're all aware, I think we've been receiving a lot of information about the challenges with respect to TNC insurance. This sets forth at least the guidelines for how much insurance they are required to have. Obviously, we still need to work on making sure that that insurance is applicable. I've heard all the stories about whether drivers have their own personal insurance, whether that's going to cover them since they're operating commercially. Those are issues that have to be worked out. But this at least gives the guideline for what levels of insurance they have to have, and we just have to figure out a way to make sure that they do have it. It has some, in 1145.15, it provides some requirement for how a TNC has to display its fare to the riders, which basically I think comports with what most of these companies do now. But it makes a requirement so they can't change that operation in the future. I think that's the gist of most of it, as you'll find. I'll be glad to answer any questions, but the main thing is that it just allows TNCs to operate under our existing code. It does not regulate them with the same level that we do regulate the taxis, which I personally think is over-regulated. But it does provide some basic safety regulation, which I think is important.
Questions?
Thank you. I appreciate the detail of this, Mr. Evans. I think you're on a good path. But my question is for Mr. Wheeler. So some of the cases that I've read and some of the information I've been given is essentially that we are treating TNCs different from taxi cabs, and effectively they are giving, the argument is they give the same service. This seems like, are we getting into trouble with this by doing that? Or what is the actual, I haven't actually found where the findings show that that in fact's the case, but do you know where I'm going? It's a little scattered, it's early yet for me.
Sorry, through the chair, I'm not sure. One of the things we're doing, as I explained earlier, is trying to take what's proposed here and compare it to cases where the industry has raised an objection either because of equal protection issues
Yeah,
or
that's my
takings
point.
issues. So we haven't reached a conclusion yet on this particular S version.
Okay, that's what I was asking.
Yeah. But our goal is to get that squared away for you well in advance of the action on this.
Okay, yeah, that's where I was going. I just wanted to know how far apart we are. And, I don't know what that threshold is. And I'm sure you don't yet either.
I suspect it's not going to be crystal clear.
Okay.
Yeah, it's going to be as many lawyer opinions are, it'll be, well, this, and then maybe this, and if that, and then maybe this, and here's our best guess, but it's not going to be necessarily concrete.
Okay, and then I have a follow-up for the maker.
Yes, ma'am.
So, considering maybe some of the regulations are potentially a little less onerous than the current taxi cab, have you considered going back into the actual regulations that regulate the taxi cabs and mirroring this?
Good question, Ms. Domboski. I believe that there are several provisions of the existing Title 11 with respect to the regulations of taxi cabs that should be revisited. I believe whether or not we pass this version of regarding TNCs. I think the issue is we have to make a more level playing field. I think we have a heavily regulated industry. I think we can't. There's a lot of people. I was frankly impressed by some of the public testimony, particularly the young woman who was testifying on behalf of her father the other night. There's a lot of people who have invested life savings, invested all they have in this industry, in this permit system we have, and have been playing by the rules and working hard. And I think it's incumbent upon us to make sure that even though I believe a change is needed to move towards a less regulated market, we do so in a manner that takes into account these people's investment and their property interests in this. So I think, and then one of the things I asked Mr. Wheeler in general was in looking at how do we go towards deregulating this industry in a manner that doesn't violate the rights of the permit holders and others. It may be that it requires time. It may be that we can't, snap our fingers and say, okay, we'll change Title 11, it's all deregulated now. It may be, I didn't look at it from a lawyer's perspective, but my legal mind makes me believe that there has to be a path that we can take. Just because we have a very heavily regulated industry today, and we've chosen that over time, doesn't mean that we are forever locked into this system. What we just need to find out is what steps we have to take and how long it has to be till we can move from all this regulation to what I believe is a more market-based and perhaps more open and freer system. And that's going to take more time than I think this committee will probably exist. But I would like to see at least that process begin, and I think it begins with the product that we're going to receive from Mr. Wheeler once the legal analysis is completed. I'm somewhat confident that there's a significant difference. I know people say that these TNCs are the same thing as taxis. I disagree in the sense they do the same function. I don't argue that they pick up people at point A and take them to point B, just like taxis do, just like some other regulated vehicles do. The difference is, and it's not to me a technological difference. Technology made this possible, but it's not a difference in technology. Yellow cab, checker cab, all have the same ability to dispatch via apps and that. What the technology did was create a different method of providing the same service. Uber, Lyft, and all those others, whether you like them or hate them, they don't seem like taxi cabs because they're doing it differently. And I think it's a difference that a lot of people like. I think it's a difference that, it's not perfect, but it's a different model than taxi cabs. And I think we should be able to have a regulation that takes that model, and that's open to everybody. The TNC, yellow cab, checker can become TNCs if they want to as well. I mean, it's just an existing mode of operation that we're incorporating into Title 11. It's a long-winded answer, but...
No, it's a very good one. Yeah, I appreciate the conversation because, I think everybody agrees we want everybody to have availability to the same type of opportunities. So when you just said, yellow and checker, they could become TNCs. I mean, that's something that I had thought about, but you're far more versed in this title than I am. So I appreciate the comment.
Other questions from assembly members? Not agreed, ready?
Thank you. Having gone over the two existing proposals that we've already have introduced to the Assembly, I did want to open up the floor to any other comments or options that any of the committee members may have with respect to other ways of going. I think Mr. Train and myself are not proposing that we've come up with the sole way of handling this issue. I think our interest is just in making sure it gets handled in some sensible manner. So if there are other options or any kind of concerns about the two proposals you heard, I just want to make sure there's time here at this meeting to address those. And it doesn't mean that you're foreclosed from ever raising them again, but I just wanted to make the option open.
We would require money, though. Or lunch.
Yeah,
Mr. Hall?
I would. I appreciate your thoughts, and I apologize. When my phone rings and it's my mother who is in a residential care, I have to answer it. And she's been trying to call her brother this morning, and she's blind, and she can't see what button to push. So after she called me 3 times, I felt I needed to go. Then her brother called me trying to get her. So I've been an operator this morning trying to connect the two. sometimes I get praised for making this comment, and other times I get beat up for making this comment, depending on who I happen to be talking to. But one thing I do believe is it's worth taking time to get this right, and I think this is going to be about as complicated as anything that we ever that we deal with in a good long while, because going by a comment that Mr. Wheeler made, in trying to work this out, I think the thing that we have to figure out is if this comes to fruition, and and in all probability it will in some form, and we allow these transportation network companies to come into the community and operate, it's holding harmless the license holders for the cabins that have been here and paid some cases a lot of money for these fees, or for these licenses. So I don't know exactly how we're going to come to that, but I hope we take time and figure out some way to be able to do that. It's important that that happen. So, like I say, I think it's going to be complicated, but I also see needs that need to be met. So I'm trying to go in here very open-minded and figure out a way that we can end up in the middle. Thank you.
Ms. Dombrowski?
No, I'll pass. Thank you.
Any other questions or comments before we move on? All right, seeing none. The next thing I had on the agenda is comments from the legal department, and maybe you provided them already in your testimony. But to the extent you feel comfortable at all, and I know you're undergoing all the analysis on this whole issue, and maybe it's going to require that to be done before you can say anything. But I wanted to give you the opportunity at this point to, as opposed to Mr. Trainee and Mr. Evans, my proposal, does the legal department have any preference or any concern about either one that you would recommend one approach as opposed to the other?
I'm listening, Mr. Wheeler.
Yes, I know. Mr. Chairman, I prefer not to be picking and choosing between two assembly members. That's never a comfortable place to be. But so I'm going to wear my administration hat for a moment. That is, if I look at both of these ordinances, what would be my preference in terms of trying to implement, enforce, provide legal counsel to the TI on how to proceed? If I had legal certainty, I think it would be better to have the code changes, because then it's permanent. Obviously, subject to some changes as we go along through the experience. But in that sense, I'm not going to engage in another negotiation when LIFT comes in. I'm not going to come into another negotiation when the next group comes in. Maybe all I do is hand them the first agreement and say, here it is, sign off or not. Maybe that's simple enough. But once the pilot program comes to an end, we're going to then pick this up again. So it's not a huge difference, frankly, but there's a subtle difference there in terms of dealing with it once versus doing a pilot and coming back to it and making changes in an MOU, which is not necessarily the same or as easy to get to as what's in code. But there's not a huge difference in terms of that administration of the two concepts. In terms of how far you go in regulating them and what you call them and how you define them and what code they apply or comply with or not, probably what we'll do is make recommendations in that regard once we feel more settled on the regulatory issues, because to me it seems like if we understand what the regulatory environment is and how we can maintain as much fairness in this as we can, then we can incorporate that through the MOU or the code changes. The difference there might be that we mitigate the litigation risk a little bit through a pilot program, because the impact is only for that 6 months or 4 months or 8 months, whatever it is that you go with. So that might be one small difference in terms of looking at it from a litigation perspective.
Let's bring up Mr. Trainee for 1 second. Do you have an estimate on when your analysis may be ready on the legality of what we're discussing.
You gave us a deadline of start September, what the date was, off the top of my head, but
Today.
today? Yeah, not today. Let's see, we come back up for a public hearing on which date? November 18th. So ideally, we would have something a week before then, at the latest.
And you
That we
believe that's
can-
doable at this point?
I think so, yes.
Straight.
Just a question, Mr. Gates. You drafted the S version of Mr. Evans, didn't you? Because I can see your style of writing in it.
Well, yes, I assisted Mr. Evans in drafting the S version. So he gave some instruction on what he wanted.
I just saw the way you write in here, so I just wanted to check. Thank you, Mr. Baker.
Thank you.
Mr. Hall?
You know, in regards to what Dennis just said, as I read the bullets in the Dembowski training ordinance here, by the time you address all those bullets, I think you are going to be rewriting Title 11, because almost every topic, everything under there falls under and inside of Title 11. So I wouldn't disagree. I think it may be better just to go ahead and address rewriting code.
Questions, comments? Seeing none.
Mr. Evans.
Oh, sorry. Mr. Steele, your hand. Definitely not, no.
In reading these two, I see that what we're setting ourselves up, that the taxi cab industry could be a transportation network company as well. So they could operate under either code, if we're happy. If they, you know, they could select, I suspect, if they're working on, if they have apps now and they're working on their apps and they're using that as their dispatch service, they can pick and choose. Is that right?
Through the chair,
With
Mr. Steele.
minimal modifications.
Yeah, I'll let Mr. Gates jump in here in a second, but that may very well be true if they meet the definitions for the TNC.
So maybe we're bringing
You could
folks
have
together more than we think.
You could have sort of a shadow of the two dispatch companies that are part of that same system offering that service. The trick there is one that we're going to have to look at, and that is to the extent that they're under a certificate and need to provide service when called, there's a little bit of a difference there, right? So how does that work if they're operating their own Uber-type system? Do they still need to maintain this certificate and provide that regulated service where they get a call, they cannot deny the service, or they have a curbside hail? How is that going to work? What's that going to look like?
You know, they have an advantage in that they can go sit and run at the airport and do other things that, but they've also got a larger investment in terms of medallions. Anyway, just
I'd like to see if Mr. Gates wanted to add anything to that.
Well, I think when we're looking at the code requirements for TNC, there's some in this S version of Mr. Evans, some distinctions that clarify how TNC vehicle operation is different from a taxi cab. And then another thing, your question about a taxi cab or dispatch company can become a TNC. One reason that wouldn't be possible is existing code provisions. There's one section that says there's only a single use of a vehicle. So a taxi cab can only be used as a taxi cab. You can't have a taxi cab operated as a taxi cab and then operated as a vehicle for hire or a TNC vehicle at different times throughout the day. You can only use it as a taxi cab any time it's being used. That what we did in the S version was enable existing dispatch companies for taxi cab services to use this same technology, to use a app to hail or call for a taxi cab. So they will be able to use the same technology, the same tool that TNC basically bases its whole operation upon. Taxi cab dispatch companies can use that as well. And that's how it's drafted in this version. But there's still some distinctions as we pointed out, that between the curbside hire or the airport. There's also only having credit card transactions, no cash transactions to a Tnc vehicle. You see, there's one section in the S version that pretty much, you see, I think it's 1140, 510 is about the Tnc restrictions, and then there's another on the Tnc vehicles in that S version. You see. 112520 on page 6, 112520B. So those two sections are basically what tries to distinguish, at least in this version draft, how the Tnc vehicle and taxi cab have to be different. Now I'm not saying that's, well, the big thing though is taxi cabs still have that regulatory procedure to go through the public convenience and the necessity process in order to get permits. It's still a limited market. Tnc vehicles, there's no cap on how many vehicles they can have here. So that's figures into the whole regulatory takings analysis.
If they go through that process, however, the risk, I suppose, based upon what you said, is that they would commingle. They would mix up. They would be operating as a passenger, an Uber type company, and then they would end up taking cash, which would get them into trouble. But anyway, just a thought that if I was in the taxi cab industry, I would be looking at my options. And the same thing for Uber. I'd be looking for my options. So anyway, just a thought in passing.
Any further questions, comments? Mrs. Dombrowski?
Thank you. I tend to believe that we do need, obviously, to go back into Title 11 and permanently address that. So I agree with you, Mr. Wheeler. However, one of the things that I'm thinking of is Title 21. And as Mr. Hall pointed out, sometimes the wheels work very slowly. So I personally don't see a reason why both of these two ordinances can't go forward. One for a pilot program in order to get the administration working, and I think out of whatever they find, I think it's going to help us develop the permanent Title 21 or Title 11. But the other thing I actually like that Mr. Wheeler said, that the trainee proposal would mitigate litigation risk by doing a pilot program. It's almost like putting your toe in the water and testing it kind of to see, but that's why I say it's a pilot program. It can be very controlled and it can have a sunset on it. So, I mean, to me, I think we really could find a way where we can kind of test the market, serve those markets that are outlying, but at the same time utilize whatever the Department of Law and the city manager come up with in the MOU that's ultimately passed by the Assembly to take the good parts and put it into the permanent change in Title 11. I mean, it's just a thought, but I think everybody wants to make sure that the playing field is fair and that the community is being served. And how we do that, under that fair banner going forward for all parties involved is going to, I think it's on the forefront of everyone's mind. But that's why I look at this and I don't see these as being mutually exclusive. I think they could complement each other, actually. So, thank you.
Any other comments, questions? Tagging on to what Ms. Dombrowski said, I mean, I'm not sure that we can put forward both of these necessarily, but it does seem like certainly the changes that are incorporated in my proposal are not lost if we go with Mr. Trainee and Ms. Dombrowski's proposal as it gives a template or something for legal to work towards. But just to make sure on that, Is there a combination of these two, or are they sort of mutually exclusive at this point, Mr. Wheeler, as far as having the assembly pass them?
Mr. Chairman, I don't think they're mutually exclusive at all. I think Amy Demboski's idea is certainly possible. Because on the one hand, you're talking about an MOU that allows you to incorporate or waive provisions of code. It's temporary. It's a one-off exception, if you will. And then your code changes could be dramatically different when you get down to the nuts and bolts of what you're going to actually change on a permanent basis. There's no reason they couldn't exist side by side.
Would there be any reason to make the code changes, like in my proposal, at this point before you've done the MOU and had the pilot program to see how everything was working?
I'm sorry.
Just the timing of it is what I'm trying to. It seems to me that if we went with Mr. Trainee and Ms. Dombrowski's proposal that goes into the memorandum of agreement and allows sort of a pilot program, it seems like it would be after the formal changes to Title 11 would take place, at least in my linear mind, after that, after we've seen how things have worked, what hasn't worked, and then the Assembly would make whatever changes it would make to Title 11. Is that how you envision this, Mr. Wheeler?
Well, if you're going to do if the concept is to do both of them together in some fashion, then I think you're correct that you may want the pilot, if I understand what you're saying, you may want the pilot first and let that experience inform your final changes. If you want to set some fairly set parameters that are visible to anybody who happens to look in code before they ask to operate here, you may want to make some of those changes early if you feel pretty comfortable you're already there in terms of what you want to do. In the absence of that, then maybe the pilot comes first.
And just so you know, the body is aware that I've spoken to Mr. Trainee about this. It is not a competition between either of these proposals. I think we just want to get some sort of solution to the Assembly. So it's I don't think either of us have any vested interest in whichever one of ours goes forward. So it's not.
Both. That's fine. Very linear mind.
I think we both agree, all of us here agree, some changes need to be made, just another review. What's going to be the right one? The pilot would allow us to figure out problems we've got out there before we change Title 11 permanently. Because I don't want to deal with it again,
Right.
like we do in Title 21 forever.
Ms. Tucker?
Just in hearing the discussion here, and I'm not offering this as an ideal model. I'm just think it might be helpful to get input from the Department of Law and others on the Assembly in terms of looking back at some of the provisional adoption models that were used for Title 21, so that you get the structure coupled with some sunset and some incorporation, and then going back to the Assembly for final adoption after that. So there have been some other precedent for trying to accomplish some concrete and accomplish the risk mitigation, and also allow the Assembly to then come back after a period and true up everything.
Okay, last word, I promise.
Sure.
No, I just, as I look at both of these, I really like a lot of what you came up with in your proposal, and that's why I would hate to see it not move forward. But I think, with that said, I think the idea of kind of testing the waters first with a pilot program, and whether this second proposal is delayed for 3 months or after the pilot program is passed by the Assembly, then it gives us an opportunity to use this as our base. And this is what we want to add, but then we already have something kind of in the hopper. Do you know what I mean? Because I think there's a lot of good stuff in here. But the whole point of a pilot program is to test. And we'll kind of figure out how the market responds to it. And we can figure out what the challenges are with it. But I think ultimately when we're doing this, I mean, I think everybody, like I said, is saying the same thing. We want to make sure it's fair for the existing industry, and we want to make sure that we do allow new ways of doing things into the current market too. So it's an interesting one for me, but like I said, I would hate to see. I think the S version is a great launching point. So I'd hate to see it just stop because we do a pilot program.
Seeing no other questions, I didn't mention it at the beginning, I should have, but I mean, I think ideally, we weren't given any specific directions necessarily with the goal or outcome of this committee is, other than to address this issue that kind of arose with Uber's introduction into the market. But ideally, and I spoke to Mr. Traney about this already, I think what I would like to see come out of the committee is a recommendation, a single recommendation. It could blend the two versions if we put those together in a concrete way. But a single recommendation to the Assembly to address this issue that is approved by this committee is the goal. There may be broader issues that don't get addressed by this committee, which we'll get to in the next items here. But I think the short-term goal of this ad hoc committee is to provide to the Assembly a method for dealing with the TNC issue. Having said that, the next issue on our agenda is because I don't think you can realistically address and change the market in the manner we're talking about by allowing the TNCs without looking at the industry as a whole and Title 11 as a whole. So I did want to put some spaces here on the agenda to talk about some of the other issues that the committee may or may not want to address. It may be issues that we put off until after we deal with the TNC issue, or it may be issues that this committee wants to address currently. But I did want to at least make the offer available. The one I've listed under number 8 is revisiting the continuing need for convenience and necessity determinations for issuing permits. That's sort of I guess a nuclear option in a sense as far as the taxi industry goes. The convenience and necessity hearings are really what drive the limited access, the limited market that we use. Currently under Title 11, the Commission has to conduct convenience and necessity hearings, and through those hearings and the finding of those hearings, it makes the determination with the Assembly's approval of how many permits can be issued, and that's what kind of governs the size of the industry and the size of the market. It hasn't been that long ago that there were discussions about opening up the market. There were proposals for opening up the market and adding a number of different permits. But I think the mechanism that if the Assembly is interested in opening, deregulating the taxi industry, it has to address the convenience and necessity issue. I don't know if there's any comments or issues about that the committee wants to address at this time, but I do want to at least have that out there as an option, because I think at some point if we talk about deregulating or less regulating the industry, that is certainly a topic that needs to be discussed, if not changed. So, any comments or questions on that issue?
Chairman, do you have a briefing you can give us on the definition of convenience and necessity? I mean, was that one that they had the legal come and tell you this is what it means? Does it exist out there?
A definition?
Yeah.
As relates to Mr. Wheeler or Mr. Musser may be the better one to give you the kind of shorthand for it, but
if you could just send us a copy of it.
I'm sorry, Mr. Chair, Mr. Traney,
If you could define for us what it actually means according to the law, we'd appreciate it.
It being,
Convenience
yes,
and necessity.
sure, absolutely. It's a term that's common not only to this industry, but regulated utility industries, electric, water, sewer, all the rest of them. And that the concept is that you have to show that there's a public need, the necessity part of it, right? And it's for the public's convenience. And what you're doing is you're doing an analysis that says, when we're talking about these monopoly situations or pseudo-monopoly situations, if you add in more providers, are you doing so such that you're maintaining the quality of service, the rates of the service, and not simply flooding the marketplace? And then what happens in theory is that none of them are making money, so the service deteriorates. So in exchange for allowing certain rates in a limited market, you're trying to control the quality of service. But you do so based on an analysis that says, okay, now we have enough growth to add yet one more permit or one more license. If a utility wants to provide electric service or phone service, whatever it might be, then they go to the commission, and the commission says, yes, this area now needs that service, and you can do things like control the rates, you can mandate that they receive the service like Solid Waste Services does, things like that. But there's this analysis as whether or not you can identify the marketplace and that there's a true need for this. So when it comes into permits, one of the cases we had 10, 15 years ago now was whether or not an initiative could go on the ballot, and we said it couldn't. And the court decided that issue. It did go to the ballot. It avoided dealing directly with the takings issue. But one of the things the court noted was that the city had only issued or auctioned off 4 permits in a 10-year span or 6-year span, whatever it was at that time. The question really is not so many, not whether it should have issued, not whether it only issued a few, but whether or not that was tied to a demonstrated need. If in the 6 years the city hadn't grown very much and the demand for the service hadn't grown very much, then you would understand that that's why there were only 4 permits issued. So that's an ongoing debate that happens all the time in front of these commissions about whether or not you need to add more or don't even.
So that study, Mr. Wheeler, would have been done before they just issued 3 permits for the Eagle Ridge, Birchwood area?
I'm sorry?
It was done.
Back in
That
90.
study?
Yeah, it's quite old.
As a matter of fact, Mr. Musser, could you forward to the clerk the results of the last convenience and necessity study that was done, just so the committee can see what it's looked at and what's analyzed and all? Because that last one did include the Eagle River issue, handicap dispatch and all. Any other questions about the convenience and necessity issue, or yes, Mr. Wheeler?
One of the things that my department is concerned about and is looking at is this notion of mandatory service. That's one of the things that comes with this end result in terms of providing these limited permits. So we anticipate that would be one of the arguments where, on one hand, a certain segment of the industry has to provide the service. This new service doesn't necessarily. Because it's so new, what we don't have, but what might be available from other jurisdictions, is what happens in the marketplace. Do certain areas of town receive less service because the taxi industry has changed and the Uber-type services come into play? But to the extent possible, you don't want to create underserved areas of town because, for whatever reason, people don't want to go into those areas. So something we'll be looking at and concerned with.
Thank you, Mr. Wheeler. Any other comments, questions? Okay, the last substantive item on the agenda is again similar to that, but just wanted to open up the topic of whether any of the committee members have any thoughts about other options that would be geared towards leveling the playing field. We heard a lot of testimony the other night from various persons involved in the taxi industry about the fairness of allowing Uber in when compared to their regulations and their regulated way that we limit what they can do and what they have to do. just was wondering if anybody had any comments or suggestions about ways that that may be addressed.
I don't.
I had comments, I wasn't sure I wanted to out them at this point without talking to legal first. But, you know, I think it just goes back to the same thing. I think we're all looking to make sure we have a new way of doing things that wants to come into our market. And we have to be cognizant of the fact that we have to be fair to the established industry. So I think we're all looking at that. And I think one of the biggest hurdles that we're going to have to just face is the fact that, you know, the existing industry might have to do things a little differently, which might mean loosening the regulations on that. And I think it's a holistic approach. I think there's certain things in there that we could do. At this point, I'm not ready to, you know, commit because I'm not the expert on it, but I'm quickly learning. So, and I think one of them is, okay, I'll just say it. One of them is I think we're really going to have to look at the option of potential depreciation of these women, you know, over a period of time. And I don't know enough about it yet to say if it's a good idea or if not a good idea. But I know it's something that I looked at last year when we were talking, when it came forward, and it was taken out of the ordinance last year. But it's something that we should discuss and see if it's an option, because what it would do too, from a municipal standpoint, I think it would mitigate any potential legal claims, honestly. And we have to look out for all the taxpayers of the community. So if that's one way to make them whole or to keep them whole or let them write off some of their, I think it's an option, and I think it's something we should probably consider. So.
Thank you, Mr. Massey. Mr. Training, then Mr. Steele.
What I'd like to see from this body is first let's adopt the pilot program, and I want to adopt yours because I think yours is the permanent solution. But I think the pilot program would give us the ability to find out what we're dealing with out there and for the administration to come up with something for us. We set policy direction. That's what the pilot program does. It sets direction for the administration what we want them to do. And yours is the answer to the problem we need to comprehensive overhaul Title 11. Just 2 years, yes.
I agree with Mr. Training in terms of the pilot program ought to be developed, and then for a period of time, whatever that period of time is, and we need to make sure that we collect the data necessary to determine the need and necessity. Because right now with the new technology, we don't really know, or the new structure, don't really know how it's going to impact, but we need to know that so that we can make that sort of determination, and maybe some adjustment in the permit issue has to be dealt with. But I suspect there's going to be an impact, but I suspect also we're going to develop new services, hopefully, in terms of eco-weather and where we get better service to certain parts of the community. So collect the data.
I would just say if that was the motion, I would second that motion, Mr. Trainer.
It was bad.
Can you clarify for the motion for me, please?
The motion is for this body to take 127, forward to the Assembly with a recommendation that the Assembly approves the pilot program. My second part of the motion is to take 2014 135S, and whatever it becomes, and have that brought to the body with our recommendation. The first we do the pilot, then we do the Title 11 rewrite with what you've got in here. You've done a great job, Bill. We just need to get it done. But I think the pilot program will give us the rest of the information we need to make sure this is a working program.
And just so I'm clear, do we need to, currently it's scheduled, I believe, November 18th is...
I would just like a recommendation from this body to the entire Assembly.
So I think what you're going at is, I think what we would do on November 18th is we would probably postpone yours for like 3 months.
Okay.
And that would give us time.
I want a firm date, though.
Yeah.
To do this project.
Yeah, exactly. That during that time, it's going to take the Department of Law and the city manager a while to probably hammer out all the issues they want to address in the memo of understanding, and then that has to come back to the Assembly for approval too. So, you know, if we go out, whether it's 3 months or 4 months, to a date specific, and then it'll give us the time to have work sessions in between and to incorporate the MOU stuff, whatever issues we're seeing. Does that make sense?
Yes.
That's what I would recommend.
Thank you, I appreciate that.
You're welcome.
There is, okay, we have a motion, and it's been seconded to move to the Assembly approval of 214-127, November 18th, and to postpone to a date certain 214-135S.
One member from legal, our legal counsel, I want.
Okay, and what is the amendment?
Additional amendment to 127, under section 2, page 2, after the list of bulleted items. For purpose of the pilot program implementation, the Assembly finds the proposed provisions in AO 2014-135S to be reasonable in approach and appropriate basis for authorized portion of transportation network companies within the municipality. It just brings yours into this. That's what it does.
So it kind of links it together, saying,
Yeah.
this is our test case. We're going to use some of the data from here to.
Okay, so you're proposing it as a friendly amendment to your motion?
It's a friendly amendment to mine, yes.
That's
Second agrees. So the motion before us then again is to send to the Assembly for approval 214-127 as amended, and to delay implementation to a date certain of 135S version.
Mr. Chairman?
Yes, Mr. Whittle.
This is a friendly suggestion. Maybe you would want to hear from the stakeholders before you make your final vote on that motion.
Yeah, actually, that's,
You're not required to.
That's appropriate.
But
it's, we have time and we have it on.
if you
the
have
agenda.
time, it might give each side a couple, 3 minutes to address their concerns. That may influence where you want to complete your motion.
It was a very friendly amendment, thank you. And is that meet with the approval of the maker of the motion?
Yeah.
And the second? Not a problem. With that, why don't we then cut to the next item on the agenda, which are the comments and audience participation. In light of everything that just occurred, I imagine there's going to be some. Sir, is that right?
Yeah, my name is Eugene Hebron. I represent myself. As you know, over the years, I've addressed the members of the Assembly and those commission meetings, how the public process of the meetings are, and also providing an opportunity for us to be heard. Yes, I appreciate Mr. Wheeler bringing up the concern about having the public speak before you do a resolution. Yeah, this has got to stop. You have these resolutions and you bring the public at the end of the meeting. That cannot happen. It should not happen. I should also further note is the meeting tonight, you got an agenda, it's not advertised. How can you legally conduct a meeting if the public doesn't know what you're doing? You're doing a motion or whatever you're doing here, but the public is blind. All they know is date and time, name of group. This is insane. I said these issues to members here in the past, and I continue to do. You're conducting a policy of indifference to the public's right to know what you're doing so they can decide whether they want to attend your meetings and address you and figure out what's going on. You know, this is crazy, absolutely crazy. And I should also like a little side note here. You hold these meetings in such a way that you already plan to have a limited attendance here. How many people here are really from the public? You know, have it not with a limited parking space. You have to go across the street, spend 10 or 15 minutes trying to find a parking space. Put it bloody back where it should be, Lusac Library. So there's no question, it's centrally located where the public can attend. Okay, and the last point here is this. You know, as you may be aware is, I've extended my review to stretch all the way to Houston City Council of Metro Borough. At the meeting Tuesday night, between the joint meeting between the Borough Assembly and the Planning Commission, there was a statement made of concern about this public process you're doing with a 48-hour notification. It was in reference to they will be planning a joint meeting between the Anchorage Assembly and the Matsup Borough. And they made a note, when I say they, representatives have made a note there of your policy that all you need to do is a 48-hour notification to have a meeting. Now, they don't do that, and thank God they don't. But you try to get them to do that when you try to coordinate meetings. This has got to stop, and they're already saying that out there. Representatives expressing concern. And even when you do that, you don't even do 48 hours. The last Rules Committee meeting had less than 48-hour notice. Thank you.
Thank you. Any other comments? Mr. Brennan?
Is it okay if I sit up here?
Sure.
Thank you, Mr. Chairman. One thing I want to stress is that an MOU, in effect, will rewrite the law, even if it's temporary with the sunset. So it's absolutely necessary under both the municipal charter and the Alaska Constitution that if an MOU is drafted, that there be a public hearing on it. The public has a chance to weigh in. That's going to become, at least temporarily, the law of Anchorage. The second thing I would say is this idea of a temporary, pilot program solution. That's not going to make the legal issues go away. Legal issues will still be immediate. And I want to remind you that there's two legal issues. One of them is the taking issue, which Mr. Wheeler briefly addressed. The other is the equal protection issue, in other words, discrimination. Treating two different parties who are similarly situated differently. And you have to beg to differ from Mr. Evans' statement that there is a difference between Tnc transportation service and taxi cabs. This idea that there's a new way, a new method of approaching things. That method is already being used by both dispatch companies. If this isn't about we need to make way for a new system, that new system is already happening in Anchorage with your licensed dispatch services. So the idea that, well, if somebody comes in and the only difference is they don't have to obey all of our laws, they can use personal vehicles instead of taxi cabs, is that really the difference you want to go to court with to defend that this stands up to an equal protection challenge? I'm confident it won't stand up to that. You have two services that are doing the same thing. One of them is subject to a passel of regulations, which, by the way, we didn't invent. We, in many cases, resisted those, but they are there, and we have to comply with them, including the idea of having to buy permits in order to operate. We have to comply with those, and here comes this California company with its highfalutin technology, which we already have, and says, come on, Anchorage, just exempt us from all that. I don't think that's going to fly in court, and that would become an immediate issue, even under a pilot program. As for the taking issue, well, the argument that you might mitigate that by just making this short term, maybe get away with that, but you're just prolonging the issue in that case because the issue is going to come up. I would have to agree with Mr. Wheeler that different attorneys are going to come up with different opinions on whether this is tantamount to a deregulation and therefore a regulatory taking requiring compensation of the permit owners. I happen to believe quite strongly that it would require such compensation. Sitting where you do, I try to put myself in your shoes, I think to myself, do I really want to take that risk? Do I want my legacy as an Anchorage Assembly person to be that I cost the city of Anchorage and its taxpayers $20 million plus for whose benefit? Uber. Uber would not pay that $20 million. The taxpayers of this city would. It might take a little while to sort out, but and different, opinions can differ on this. I've looked into this issue a great deal because it came up in connection with the initiative deregulation issue, which the Anchorage voters passed, by the way, 65% to 35% 7 years ago. And I agree that the Alaska Supreme Court has a stronger standard, that there's more vulnerability for requiring compensation for regulatory taking than under the federal Constitution. And so I would throw a big note of caution here on going with even a pilot program to address this thing. The more this issue has been aired in Anchorage, the more it's become apparent that the two services are one and the same. The only difference is one really is deregulation by another name, which yes, many people favor, but this assembly or prior assembly adopted it. It is the code of Anchorage, and you can't just toss it out the window by disguise or otherwise without having to compensate the people that have played by the rules.
Are there any questions for Mr. Brennan? Thank you, Jim. Any other comments? Sir, Mr.
All right, if I take the same chair?
Sure.
Well, my name is Bryce Bennett, from Uber, as you know, last week. Wanted to thank the subcommittee for taking the time to really dive into this issue and really work through what is going to be best for the citizens of Anchorage. We look forward to working together on the option that you guys pursue moving forward. We'd also like to further the point, though, that really we don't view this as one and the same thing. Just because someone moves from A to B does not necessarily mean they fall within the same kind of business model, the same kind of operating procedures. We agree that more transportation options will be better for riders and drivers, both in Anchorage, and further concur that we will work to service these outside areas, not only the Anchorage core, the Eagle River, the Chugiak, and the Birdwood areas. If there's any further questions, my team is available. We'd love to answer them for you. But we look forward to moving this forward and finding a permanent home in Anchorage here.
Since the issue of insurance keeps coming up,
Yep.
have you guys given a copy of your insurance document to our attorney?
Yeah, yes, and we have a hard copy here that I can hand you as well.
We don't have it yet.
Okay, it's
Well, he says he's got a hard copy here. I want to make sure you get it, Mr. Wheeler, Mr. Gates. Okay. Thank you, sir. No other questions?
Thank you.
Thank you.
Good afternoon. I'm Susie Smith, and I'm a permit owner and operator. I just want to bring it to your guys' attention because you guys spent most of last year rewriting Title 11 and making some changes where you felt necessary. And up until then, you were satisfied with it. You had, at that time, decided to add 15 permits, which generated about $1.3 million to the assembly, went to the city, went to the general fund. People that invested a tremendous amount of money for those permits. Now we've got a company coming to town who is an out-of-state company, $20 billion company coming to town, and we're just going to issue them the same rate that these people paid $1.3 million to. I think that's really backwards. And in that rewrite, you guys also lifted what we have our lease cap that we charge our drivers, and you did that, which was a tremendous help to us as operators because that rate I had been operating with that same rate since 2001, the exact same rate. So 12 years I had been operating with the same exact rate that I could charge the drivers, and it's been a tremendous savior for me. I've already changed a third of my fleet, which is I run 34 cars. I've changed a third of my fleet right now to more fuel efficient, newer vehicles. And I didn't do that with a mandate. I did that with my own personal desire to change my business model and to help foster, but I couldn't do that when my hands were strapped with the rate that I had been for those amount of years. So thank you for doing that last year. Yeah, it's just frustrating. It's really frustrating to sit on this side and be a participant in a system that we've all worked really hard for, and now to throw it all the wayside and pretend that we need to now have a pilot program for our company who's shown that they can do what they're doing just fine. I mean, a $20 million company doesn't, in my mind, need a pilot program. So I hope you guys do take this very seriously and spend some time and don't just think you need to make something quick and fast. You've got hundreds of families that have invested in this and that rely on it. It's not a light matter. Thank you.
Hi, my name is Kim Baby. I'm not an owner. I'm a driver. This is how I pay my bills. Excuse me. For you to say that, this company can come from another place. They're not from here. They don't know our ways. They don't know our people. They don't take Medicaid. Do you realize how many of the outlying village people that live in those villages use Medicaid for transportation? A lot of them, almost all of them. They don't accept it. That's discrimination. They don't accept cash. That's discrimination. Our Lifeline programs here do not offer data for the lower income people. So if you can't afford to pay however much it costs to have data on your phone, or even a smartphone for that matter, they won't take care of you. But I will. I don't care if I pick up in Mountain View. I don't care if I pick up in Fairview. I don't care if I pick up in Chugiak, Fort Ridge. I don't care where you call from. I will come and get you. I drove from Spenard to Elmendorf Air Force Base today to get someone in their car so they could get to work on time, one of our soldiers. Can they say that? They can't. Because that's not a service that they offer. And yet, we want to allow them special privileges. Because that's all it is. Special privileges. Their drivers don't have set hours so that they can work. According to what I just read in that paper, that was crossed out. That's not fair. I can only work 12 hours. I guarantee you, I'm a very healthy woman. I can definitely stay on that road more than 12 hours a day and make more money. But I abide by the rules that this assembly has decided is fair and safe for the public and me. So how can you justify setting that aside for some out-of-state company that comes in and says, well, we have it only on the internet, so we're more special than anybody else. We shouldn't have to follow the rules. I have to. Why don't they? And I'm not an owner. I don't have hundreds of thousands of dollars invested in this. But this is how I feed my family. And you're jeopardizing it. And I have gone to Eagle River and taken a trip to Cars. I will go to Eagle River and Chugiak and Birchwood and all of that for what we call an inner trip. I don't mind. But we don't have the calls. If they're there, I'll go get them. If they want a cab, I'll go get them. And I'll tell you, I used to be a dispatcher. And I used to tell my drivers, they'd say, where are they going? And I would tell them point blank, I don't care if they're going across the street, go pick them up. And that is how I believe, and that is how I run my cab. Please hold them to the same standard that you have held us to all these years. To do otherwise is unfair. Thank you.
Hi, I'm Jackie Ransom. I'm a permit owner and operator. My husband also drives taxi. I just wanted to state that I've been involved in this industry for over 30 years. My family, my father bought our first permit because his father drove a cab in Illinois. And he worked for the Bureau of Indian Affairs, and it was that tie with his father that he bought his first permit over 30 years ago. When he passed away, he left it to my mother. And when she passed away, I bought it out for my brothers and sisters. it's an investment. It's a way of life in our community. These aren't rich permit owners raking in the dough. I live in a little house in Spenard. I pay my taxes. I've lived here. I've gone to high school here. I've gone to junior high here. My whole family here is here. I hope to leave that permit to my daughter and my son. And I hope they operate with the pride that I do. First, we've worked, Susie, all of us permit owners, we've attended your meetings for the last 2 years. I've been to the safety committee meetings routinely. I've been to the Title 11 rewrite meetings. I've been to the Transportation Commission meetings in hopes of a healthy industry. What you're contemplating here is not making the industry healthy. It's trying to make a special privileged group have carte blanche to come into our city and do whatever. The state of Nevada just put a withholding because they have a very strong transportation commission for the whole state, not just the city. And they just opened up in Nevada this last week in Las Vegas, Reno, and the Capitol. And they said, no, you can't. You have to follow our laws. And they put a cease and desist on them. They fine those people $10,000 every time they find an Uber driver, and they confiscate their cars. $10,000. It's all, you can look it up in the newspaper. This all happened last week. They impounded 3 cars, and there was several $10,000 fine. Uber's still driving and still dispatching. These people are not following the letter of the law. I think that is very a slap in the face. They come to town and say, we're special. The Division of Commerce for the state of Alaska issued an alert last spring. My husband sent it to you in an email this morning. Be aware. It says that independent operators, which Uber says they have, should all have business licenses. I don't believe Uber even looks at the state laws. I don't believe they even look at the city laws. They don't give them about it. All they care is being able to do what they want when they want. And I have a problem with that. Who's going to enforce this period? And where are you going to get your information when they go through this trial period? From Uber? They have shown time and time again, they don't care what you think. They're going to do whatever they want. They're out there running now. The 2 or 3 drivers that I know personally for Uber couldn't qualify for a medical to get a taxi chauffeur license. They're unhealthy and they're driving for Uber. The other one has numerous driving offenses and our commercial insurance wouldn't even cover them. That's 2 of them I know personally that can't drive taxi cabs because of their driving record or their medical health. That is a safety issue for the public that the Assembly is supposed to be protecting. Right now, if they're driving free, giving free rides, is Uber paying those drivers? Who's paying for those free rides? I know those guys are not doing it for free. And if Uber is paying for those free rides, who's paying their workman's comp? I bet you Uber isn't. Who's doing the taxes on them? And I don't think they have business licenses or anything else. Nobody checks this. You just go word of mouth. Oh yeah, we got that covered. But they're breaking state laws, they're breaking city laws, and everybody is so ready. Let's do a trial period. The trial period's been right now, and they're still breaking laws. They got a cease and desist, and they're out there. Has anybody checked workman's comp? Has anybody checked any of those issues? I don't know. Uber's paying for those free rides. They're still operating in this city. So you are, the liability is on the city for those free rides, or the judge of the state. Whose liability when they get in a wreck and that insurance doesn't cover? Because you guys have all rubber stamped, yeah, we're ready to do this, instead of going through the steps first before and make them legal, that they have the license, they have the training, they have the necessary insurance. We all have the city as a co-writer on our insurance. If our insurance isn't paid, an immediate notice is given to the TI, and we are off the road that day. That is it. You won't have any controls at all with with the program that you've got going. I mean, their word in numerous states has not been very sufficient. There's lawsuits all over the country, and more states, as they've been doing business, are outlawing them and trying to 86 them out of their locality. Maybe a few cities, they were successful, I don't know. But I know if you Google it, there's more and more complaints, and there's more and more problems with it. And here we are opening the door and saying, carte blanche, go for it. The other problem I have is surge pricing. You go on a trip, one way, $20. By the end of the night, it could be $200 to get back home. They have surge pricing. They don't have standard rates. And you heard in that public testimony, I wasn't able to be here because I was out of state. I was listening to it on the internet, and I appreciate that that capability that you can listen to see what's going on. But in that testability, they said, well, I think you asked, what happens on a snow day? What happens on a snow day when everybody's jammed up? What's your price going to be? You know, you guys had a heartache about raising that meter so these guys could get 75 cents more a trip, which was less than $15 a day because the average cab driver has 15 to 20 trips, basically. So you gave those cab drivers maybe a $15 a rate increase. But these people could just at whim change their rates? I don't understand that. How is that protecting the public? Maybe it doesn't hurt the high end of the public, but you know, as a middle income person, I think if I took a trip and it was $20, I would assume, and I might not have that $200 coming back from the concert, you know, or coming back from a night out, and it might hit me and it might be, oh my God, but I don't have a choice because it's automatically taken out of my credit card or out of my bank or whatever. You have to have that before you sign up to be an Uber customer. And then if that driver, you and him get into difficulties, they kick you out. They kicked out Mr. Muser. He was a Uber customer, and he took a trip, and he gave him a citation, and he got 86 out. Oh, that's great. The transportation inspector got 86 out of Uber. He's no longer a customer. What's he going to do when that driver gets mad at you all?
Mr. Ransom, there's a question. Mr. Hall?
Yeah. And Jackie and Susie may want to be a part of this. This is for my own edification. You mentioned workman's comp.
Yeah.
I was cornered by a driver at the last meeting, and I had no idea who he was, so up front with that. But he told me that in order for him to drive, he had to have $100,000 worth of insurance to cover the cab, and that he had no comp coverage. How exactly does it work as a permit holder? I know that works a number of different ways. There's people that lease your permits, etc. But can you kind of give me a clarification on what that individual may have been talking about?
I don't know what I don't require, workman's, they're independent contractors to lease my car. And so in that way, they pay a daily lease, like a rent.
Right.
And then anything, they have to leave the car clean and full of gas. That's what he has to do. Anything, what they make over, that is theirs. And they're the ones that keep track of their own taxes. And if he wants to pay workman's comp, he can pay because he's an independent contractor. Just like as if I was a grocery store owner and I rented the building, I would pay certain things. And then what that grocery store owner over those certain basic costs. You know, he was having to, pay his retirement or his insurance or whatever. Yeah.
I think I know what you're referring to, and that is drivers, when they're self-employed, he doesn't have like medical coverage. And so the insurance that he's referring to, there's only insurance on the vehicle and for the driver when it's the other person's fault, right? So the other person's coverage covers that driver. Or if there's uninsured motorists, then our insurance covers that driver. But there is no coverage for the driver if it's his fault for an accident. there is no medical coverage for him, if that's what he was referring to. I'm pretty sure I know who you're talking about.
I have,
And so because they're self-employed, they are allowed to buy their own medical insurance, and that's probably what he's referring to, and we don't provide that.
Eric has it.
Yeah, to the chair. Thanks, Mr. Hall. The taxi industry went to the legislature in 1993 asking for an exemption from the workers' comp laws of a specific taxi exemption. In 1994, the legislature granted that exemption, and it applies today, largely due to the independent contractor status. So accidents, where it gets a gray area, it's actually paid by everyone that has insurance in Alaska to the state pool. It becomes a public liability. Regarding Uber filed notice with the state yesterday contesting workers' comp, or the state's position in workers' comp. The drivers that have been referenced to, the driving now are subject to that, or employees or anything else. They served yesterday a notice of appeal. The state workers' comp rendered a decision, a preliminary determination that is subject to the workers' comp laws, and the employees of Uber Razor, Uber served notice of appeal yesterday.
I just don't see how we can do business with somebody that is filing appeals and doesn't want to follow any of the current laws in place, or even give consideration to any of the current laws in place, Do the talking first, get it signed, and then open the door, just like you did with us. You have the contract, you negotiate the contract. They want to come, then negotiate the contract, then open the door. But this trial period, my goodness, what's going to happen when that Uber driver gets in a wreck or whatever? God forbid something awful happens. They say background checks. Are they FBI background checks? Who knows? Or did they go on the internet and get that 495 thing and see where all the home, legal, and whatever liens on your house or whatever it is when you want to look at some people? I don't know. Do you guys know what kind of background checks they got? Do you know if they got DOT physicals that you're requiring us to have? They are transporting the public. Mr. Trainee, you were very big for the last 2 years on Title 11 rewrite for the safety of the public. We put all the car recommendations, check the tires, check this, check that. It's all in the title. It's not, car check. It's written out, ABC.
1 second, Ms. Ransom.
Oh,
Mr.
yeah.
Hall is following.
yeah, and Jackie, I don't know if you have the answer to this or not, but I'm curious, when did the being able to use an app for cabs, when did that start?
I know I'm at Checker Cab. I know Michael Thompson has been working out the bugs on it for over a year. The Android part of it started, I think, 3 or 4 weeks ago, and the Apple thing, I think it started last week or something. And I'm not familiar with the Yellow Cab.
We launched our app September 15th for Alaska Yellow Cab, but Mike Thompson, a number of years ago,
He has been working.
launched an app that was deemed to not be following Title 11, and it was struck down, and that equipment had to be stripped from his cabinets and replaced. So although the current versions have only been in place for a little while, a previous attempt at running it years ago was tried and struck down by law.
We,
Just
my
so the record
husband,
reflects, that was Mr. Unwin for
Oh,
Yellow
for
Cab.
Yellow.
And I'm sorry, I didn't get the date. So,
For the current versions or for when Mike was running earlier?
okay, thank you.
several years ago, my husband and I, we were a member of the Taxi Limo and Paratransit Organization, the national organization for taxi cabs and limos and stuff. We've routinely gone to the conventions to look into new technology and things. Several years ago, we wanted to do a network dispatch company, and we ran it by the transportation inspector, and he said, no, it doesn't fall under the Title 11, because that's what we wanted to avoid, those costs of the, the building, the 24-hour employees and stuff because they are high cost. They are a big, big investment and they're very spendy. And so we tried that several years ago and we were told by the city, because, you know, before you invest, you run it by to make sure you're legal, unlike other companies. And we were told at that time that we couldn't do technological dispatch because the dispatch had to be local based. It had to have a building in this city. It could not be on the internet. And, you know, times change, I realize that, but before you change the times, you better make sure what ocean you're jumping in before you get way over your head. But we did look into those things, and they've been around forever. And like you said, Thompson has been working on it for years, and he keeps running it by, and you know they finally got it approved. It's not new technology. It's not different. It's serving the public, and you have, you know, the assembly and the public has thought those laws. You know, I read those comments on.
Can I interrupt just a second?
Oh, I'll let you go.
I'm just saying, we have about 15 minutes, and if there's
Anybody
any
else?
debate, we're not going to have time for it if we don't
Right, I
move
think
it along.
Bob wrapped up.
Sorry, Jackie.
No, I run on.
So do I.
Anybody spoke, sir?
I have just something briefly on the workers' comp question, if you're interested.
Duly noted. Sir?
Yes, sir. I'm a permit owner. I drive the cab last 25 years. Never been called in by TI last 25 years. Never have a complaint against me. The only thing I want to ask you guys, I bought this permit, pay the city. That's my son college money. He's going to graduate this year. And by the way, he's a valedictorian, going to be valedictorian from Service I. But I had to pay his college fee. That's what I thought. I'm going to make money with this permit to pay his college fee. So you guys, letting you know that if you guys did this pilot program, what pilot program? If they're not paying all those cars just like a cab, each permit. Each car they put it on the road, that's one permit. They're not paying anything. Can I be exempt next month paying $2,000 to the transportation inspector? While this program is work, so I don't have to renew. I can renew my permit without paying $2,000 while this program in work. That's I don't write anything, so I usually forget what else I want to say. But that's the main thing I want to say. That each car, if we pay each car $2,000, they should. And none of their driver, the insurance, they might have some kind of insurance while their app's on, while the passenger is in cover. I want to get the copy of that driver. You guys all have the insurance. Can you call your insurance agent and ask him you are driving for Uber? Is this okay with them? Tell them Uber have insurance when you have a customer. Or when you turn the app, they have some kind of insurance. Tell them that, but ask them, but you are transportation doing their customer. Did they let you? I talked to my agent. He said, you kidding me? I've been with him last 25 years. So those are the couple things I have. Please don't take my son college money away from me. The second, if they're not paying anything on those cars, $2,000, since this pilot program working or whatever, I should not have to pay $2,000 either next month. I believe it's due next month. That's all I have to say. Thank you for your time.
What was your name, sir?
Nasser Chima.
Thank you.
Thank you, sir. With that, we'll end public comment. And just so everybody is aware, we're not passing any laws today. What we're doing is making a recommendation to the Assembly to take up this matter on November 18th. At that time, there'll be additional public testimony, and the whole Assembly would have to be involved in passing any law. The motion before this committee is to put forward AO number 214-127 for approval on November 18th as amended, and to delay to a date certain action on 214-135 S version. Okay, with that, we have a motion on the floor. Is there any comments?
I'll just reaffirm my support of this path forward, and I just want to say, nowhere in here is people saying they can't they won't be subject to the law. Every little bullet in here basically mimics Title 11, which would have to be addressed. And to ease the mind of Mr. Brennan, any MOU that's developed will have to go to a public hearing because this ordinance says that it has to be adopted by the Assembly. So it will be publicly noticed and it will be open for comment. So, I think this is just a mechanism in order to get the conversation going. Nothing in here says that it's going to be passed and they're going to be automatically have carte blanche to do whatever they want. I mean, that's just a fallacy. So I just urge this path forward. I think it's a logical one, and I think it's a measured one. It's not just free reins. So, thank you.
Mr. Hall?
Yeah. Actually, I'll just point out a fact. Both of these, regardless of what we do, both of these are before the body. I mean, any recommendation that we make one way or the other is going to be debated at the night of the meeting. So I don't know that we even need a motion that it goes that direction because they're both before the body and they're both before the body for action.
Any other comments, concerns? Okay, seeing none, I would just like to get a vote of the body that this is the committee's recommendation. So all those in favor of the motion, please signify by saying aye.
Aye.
Any opposed, same sign?
Yeah, I'm going to be a no because I believe it's before the body already.
With that majority vote, this committee will recommend to the Assembly passage of 214-127 and treatment of the other ordinance as described. With that, we are adjourned.